And when he came back, instead of his lawyers, the former Attorney General, Deputy Attorney General, to come so that interrogation would be done, he chose to rather be granting interview in his office and in the media and calling into radio programs to say things that he knows are wrong.
Your account is frozen. To freeze your account, there must be a specific motion for that. Not be granted.
No.
There's normally,
I believe you are being investigated.
The first one. This
account freezing is specific. And the judge says that the recent development means the present application is moot. There is no valid freezing order. There must be a freezing order. You think everybody being investigated?
Please, what you are saying is not the case.
This is a ruling of the court. He says there's no valid freezing order.
That concludes.
The judge says so.
Bernard,
there is no valid freezing order.
He's reading the very last paragraph.
Look at that. Is there? The judge says so.
This recent development renders the present application.
He is claiming that, and I am telling you that most of the time yesterday was spent waiting for him and his lawyers to come, and he never showed up. I think it was the same time that he was on TV and radio granting interviews.
Is against
Samson.
The application is therefore.
So why can't he take
the judge is saying
no.
Please allow me to develop my point. No. Please allow me. I am saying that there is the administrative power.
Freezing.
So it is not the case. Senior Bentel is not correct here.
Instead of him to accompany his clients to do interrogation through the interrogation, he's sitting on TV, calling to radio programs and talking. But his client will be going for interrogation today. He was discharged yesterday.
Now, two NPP communicators were about joining you, sir. One NDC man decided to dismantle every Akoshibia with all these years. Now, this is trending on social media. So, once I share video in the form of WhatsApp, maybe share what in the comment section, but straight to the news. Now, you would remember that on Charity, there was this Hanan Abdul Wahab, the former CEO of the National Food and Buffer Stock Company, which is the NAFCO. Now, I know some about this. Charges was a quid was about, which is quid was about Sika Chrono Semi be money laundering who some sebi na we to no or the new position who some sembi. I want some of you who cry. Now, Papa, some no good work our court no season maybe we doing there charge could draw what the one pine there apart from Scasamano or the new position as during the period and another the president, which is between 2017 and the boss for 2017 to 2025, or the new opposition or the pill Sikebia, which was not supposed to be so. Now, according to Damas Sikasami, where two monowa for it is in court CCR, the Attorney General case in CCR. There was also additional 20 criminal counter on Oma Sam Procura Susuru. Now, on Procura problem. I program make problem. In some of the bana yet at it, even or multiple. However, courts will be receive a prosecution in a chair. Oya papi, no lawyer, which is girlfriend, or dame. Etumono, I come a court nata, say there, uncle, na uncle abruchimim, na uncle share, na yarasaka, because Nua oya yell. Courts in the man akunya, the old. For Fabra, na yam to me yam fanya jinadona, yan shade, so obey that one samano, or that question who was a Oyabuchimema, no problem, Butumako. Or the bay, caught in the shade. Now, caught in the shade now, or Babacono, or Duku to go international airport, no, Enna, BNI, with regards to Attorney General, who pay for Bebrino, or arrested or Oye Kotaka International Airport. My NPP would J, there was a lot of social media posts and some year baby there. Hanan Abdul Wahab, NDC for Oye Demi. Son and something in the corner. Now, since something in the corner, you're based on some very specific things. And in the headlines, you're about to now, and some of Kodo will join you, as hosted by Samson Yenedy. Now, you could see there the Honorable Bernard Bardoo. Too much there. In your day, and some NPP for what can on your corro. And some more can in our quarrel. But what can one tasi into the Oma Wakasano. Because Embrana Chede say, Woma Wakunya there to con naka show whom warrior Buchimima. For Yama be Fabra, and Yamana the Beno. Imagine that will be our home for. Na Kratena, what's the matter with the Focono? Krateno, or it's Chede. Doctor Chede, Ame, Mini oye honorable Hanan me ni din komo doctor no reka se dio me ni din komo wie ni no e na mo hu ne de demi on sisi ni ti no me refer na me yama doctor yi bi wo abruchi dem roba yobotu wa hwe ne ho. This report no e na the honorable Bernard oye Bardoo Richard dama letter yi pokrai as a referral letter no kra onzibo on yakor inti say court no pokra ma na akunya do on traveler court pokwa why dey but sent na watch ni biom no e because say it is a some court na so no dem inti wa ma akunya that traveler how come there other sense ko bank wo banks nyina we freeze at this time because of sika won semsebe was that wa forward ni inti no wo banks we won sa or that to sika samado na ekọ bank no wode epede try na iyi wusika epede try na fight bank na nka omo wusika kakra wa bring him the way freeze bank it is totally against the law dama asem yoya against the law yi ono na NPP for want to want chire me ye won amanfo na worry ye deda worry ye no according to honorable Bernard Bardoo na nsam no edu pempedu bia since an wa arrest ni biom no wa ma NPP for want to manda two communicators were about join news to try and prove that as some work once a boom, but they took just one person to just dismantle Akosha Wilson. And someone was so much pathetic. Bomazana share video will be WhatsApp. You go straight to the studios of Join News Navia.
Grounds. The reason you see the affidavit deposed to by the office of the AG to be affidavit in response was that the first day when the case was called, the AG had not even filed an affidavit in opposition. In fact, but the was in court, and the deputy AG raised issues that they are not in principle against his travel, but they want to see certain document. And the document, of course, to prove that indeed he needed that services outside.
Oh, okay, now that clarifies it for me.
Yes.
That's why they intentionally didn't call it opposition. Okay.
And it is even here, when you read paragraph 5, you would see that they said that they are in principle not opposed. You read it to the
paragraph 5. The Attorney General is in principle not opposed to Hanan being granted leave to travel out of the jurisdiction for medical care.
Absolutely.
However, Hanan ought to provide the following particulars to enable the court to properly and effectively consider and determine the application. And then he brought those things.
Those are the things.
The court granted him.
And on the day when the application was moved, the AG was opposed to those documents. I mean, the document, they thought that it wasn't really documents that of course, they did. And then the court still ruled that he be granted. And that's where I feel the AG should have, because after I've also seen, something, you've also seen the documents that Hanan presented to the court as basis for that application. I have issues with them. A lot of people are
questioning the judge's judgment.
No. I disagree with him, and I have that right. I disagree with the judge, respectfully. And I thought that the AG should have appealed. The AG should have appealed immediately.
So this is how to backdoor appeal?
How a backdoor appeal? No, I'm coming to the issue. Not at all. Okay. I'll deal with the issue. But I'm saying that, for starters, the AG should have appealed. Because these documents are not enough. Something with you've done this for a long time. Look at the documents you have. In fact, and it's good that I have to deal with it. It's important. One of the documents is a document from Makafo Eye Services Limited, to whom it may concern. Look at read the first paragraph. Mr. Abdul Wahab consulted me at this Legon clinic with the view of getting a referral letter. Is that how these things are procured? Is that how they are procured? This is the document he presented with the view to support his appointment with an ophthalmologist in the UK. Is that how it's procured? Look, these are the documents he intended using to procure the order.
He has an appointment with an ophthalmologist, but there must be a referral.
A referral.
Then he sees a doctor to say, yes, I have an appointment, but I need a referral.
No, you see, he is saying that he look, because if you read what the AG said, they required a document, an acceptable official medical certificate of diagnosis. It's never here. He never got that. This is not a diagnostic document. Do you understand? Something, because anybody can get this.
No.
Anybody, please allow me. No, anybody can procure this. anybody can procure this because it is not business as usual. He needed to convince the court that he needed those services outside the country. And this, for me, is not enough.
Kofi Bentil said it's enough if you read the letter in full. Is that not what you're saying?
Where does it say?
The last paragraph says, my impression is that Mr. Wahab has alleged conjunctivitis. I have explained to him that he is a qualified doctor. I have explained to him that this is not curable but controlled with anti-allergic eye drops.
Where is the diagnostic report?
Did you hear what I just read?
No, but this is my diagnostic report.
I beg you, a doctor says...
So allow me. No.
Okay, so it's okay.
So
let's agree. He's challenging.
What's the form of a diagnosis?
He's challenging both the doctor and the judge. So let's go.
But I'm saying that I have a right to disagree.
What is the form?
Continue.
Let me continue. Now, so that is what happened. The court ruled. The AG didn't oppose. So of course, the man was at liberty to travel within the terms of the order. Now, this man from there goes to his bank. From the court, goes to his bank and presents a document to the bank.
A court order.
Relax, please. He presents a document to the bank. And the document for him...
We don't know how the document was presented, whether he went there or he sent it by email.
No,
So you said he goes to the bank.
The information I have is that he was there. Okay. That's the information at least.
I've heard conversations that suggest that he just sent it. He didn't have to go there.
Well, I know. I've also...
Okay, go ahead.
And then, you see, when he presented the document to the bank looked at it, of course, because the bank has received an order from the court freezing the account. And so if you go... And the bank...
Long ago.
And you see, the bank is not a party to the suit, the matter in court. They would not know whatever happens. So this argument that it automatically discharges and all that, no dispute. But how would the bank be in the know of what has happened? You
to be brought to the bank's attention.
Yes.
And so you, please.
Oh,
so you certainly have to bring a document to the bank to prove that there is a defreezing order. So the bank looks at it, first and foremost, the order that was served on the bank had a suit number different. You may say, do all the argument that they are in respect of the same case. The bank is not a party in the matter in court. So first, the suit numbers are different. Secondly, there is nowhere in the ruling of the court. This is not an order anyways. Let me put it this way. It is a ruling of a court. And Sam, you agree with me?
What is the effect?
Oh, the effect, yes, but we've been using this. We are doing.
Go ahead and make a point.
So I'm saying that when the order, this document was brought to the attention of the bank, and I state here that there is nowhere the court refers to any account number. In fact, when you read the first paragraph, the court deals with the 4 items that were in the order for the freezing, as in the Identity High Court that he went. The court never mentioned any bank account. But you see, I haven't read this ruling. The judge is a very smart judge. Why didn't he grant the order but had this struck out?
Grant the order?
No, but the
because
order...
he was telling them that
yes,
you have come to court for something.
Yes.
But the thing you are coming for, you don't have to come for it because the charges have been withdrawn.
So relax.
And since the charges were withdrawn, everything that was done on the back of those charges have gone with the wind.
Hold on, let me deal with certain things he said.
All right.
The judge, yes, as has been read, the judge said this. He said it is common knowledge that the applicant has since been rearrested. Don't forget the Yoko law, the Yoko law, that is it? Yes, section 33, which gives the Yoko some orders without even going to court and freezing. They have that right, but after they are done, they have to within 14 days.
So finish reading it and make the point.
I'm reading it. Yes.
It is common knowledge.
So it is common knowledge that the applicant has since been rearrested. The development has a direct effect on the present application because the withdrawal of the charges against the freezing order has automatically discharged. Was automatically discharged. The rearrest begins another process as the applicant ought to be cautioned and charged with an offense. The first thing we should ask is that, was he, after the discharge of the of those charges, after it was withdrawn, was he rearrested or not?
Yes, he was.
Mm-hmm. Do we know what he was taken through? I am aware that he was placed on investigation and he knows it. So,
go on.
So the judge is saying that the rearrest begins another process as the applicant ought to be cautioned and charged with an offense, which was done. The caution statement taken from him on the 26th of June 2026 is no longer in force. And which is true.
It's no longer enforced
to trigger investigation and possible charges because it's been withdrawn. So the judge, yes, it's true. There cannot be a freezing order in respect of a property where no investigation or prosecution is ongoing. So the judge is a smart judge. But you should ask yourself whether there was an investigation ongoing. Yes, there was. When he was rearrested, he was taken to Yoko. So the judge is saying that on what you brought, there is no issue. Because if there is no investigation ongoing, it is automatic. But if there is, then this doesn't apply.
If you were in private practice,
yes.
Still,
yes.
I don't know if you still go to
yes, I do.
Okay.
Yes.
And Abdul Hanan was your client.
Yes.
Would you have interpreted this decision the way you are doing?
I agree with you, but if you were also the Attorney General,
would you not have told your client that you need to bring this decision to the attention of the bank, that the freezing orders have been discharged?
Samson, if that is even where I, with the greatest respect, fault his lawyers. Look, what he should have rather sent to the bank were probably court notes in respect of the charges on the, that particular, the account thing, or that day when the charges were withdrawn. The court note would have served him better. Because this one is in particular in respect of 4 properties which does not include an account.
The value of
there is.
When you have a court order.
No, which court order?
You have a ruling.
Which court order?
You have a ruling. Hasn't read all the necessary parts.
Where?
Okay.
Where?
See, he says that there cannot be a freezing order in respect of property.
Is that what I read?
No, you didn't go there. Oh wait, where no investigation or prosecution is ongoing now. An investigation or prosecution is not equal to
He disagrees.
No, I disagree. Go and read the Yoko law.
He disagrees that there cannot be a freezing order when investigation is.
Here's the point. Please, then let me make one small point.
No. Bernard,
you have a bank
you are not listening to me. I'm saying that you are making the contrary point against what the judge said.
Yes.
From where you said the judge is wrong on that point.
No, the judge is not wrong.
My point is
no, the judge is not wrong. I think
it's an important point. You can be investigated for so many things. Doesn't mean your account is frozen. To freeze your account, there must be a specific motion for that. It must be granted.
No.
There's normally.
If you are being investigated, your account is not automatically
the first one.
This specific. And the judge says that the recent development means the present application is moot. There is no valid freezing order. There must be a freezing order. You think everybody being investigated?
Please, what you are saying is not the case.
This is a ruling of the court. He says there's no valid freezing order.
That concludes.
The judge says so.
Bernard,
there is no valid freezing order.
He's reading the very last paragraph.
Look at that. It's there. The judge says so.
This recent development renders the present application moot. For there is no valid freezing order in the first place following the withdrawal of the charges against
Samson.
The application is therefore
so why can't he take
so the judge is saying
no.
Please allow me to develop my point. No. Please allow me. I am saying that there is the administrative power.
Freezing.
So it is not the case. Senior Bentel is not correct here. It's not the case that at every point in time you need to go to the court to procure an order. It's not true. You can do that. The Yoko under 33(1), they can do it, but within 14 days they have to. And I'm saying that there is no dispute as to whether the charges were withdrawn. And the judge is operating on the basis that those charges under which you are before me have been withdrawn, so you don't even need to come. But the judge said if there is no pending investigation, I am aware that after the charges were withdrawn, he was rearrested, put on another investigation, and he was informed on what is available and what is not available. And so for me, if that was that charge was on him and he was being investigated, and the Yoko office, as I'm hearing, freezed the assets from there, then the Yoko under the law of the Yoko, the 804, it kicked in. What they should have probably done, beyond the freezing, maybe within 14 days, they ought to go to. So if they are saying that there was no freezing order because the charges were withdrawn, that is a fact. And the judge smartly said that if that is not there, then the reason you are before me.
Guys, I think you should listen to Bernard a bit here. He says that when the judge says, wait, hold on. When the judge says there cannot be a freezing order in respect of a property where no investigation or prosecution is ongoing. What the judge was suggesting here, according to Bernard, is that for as long as there is ongoing investigation, there can be a freezing order.
Respectfully.
But again, how do you marry that with the final statement in the ruling, where the judge says these developments render the present application moot because there is no valid freezing order in the first place?
So something simple. The answer is simple. It's expressio unis. Kofi. It's expressio unis.
Yes.
This application was not ex parte.
Which one?
Yoko was there. The respondent is represented by Rabiatu Abdullahi with Ebenezer Jiman. So Yoko was there.
Samson.
So it is not a matter that you can say that the judge was making statements out of 10 in the absence of the relevant parties. Both the applicant and the respondent were in court, represented by counsel.
Samson.
What are you talking about?
Samson, I am saying that there is nothing.
But you said it. Samson said it for you.
Please.
We were responding to Samson. He was speaking for you.
I listened to you. I have a few other things to say. Please, allow me.
You let him finish.
Let me do. Okay. There is nothing wrong with what the judge said.
Okay.
There's nothing wrong with it because the judge premised it that if there is no ongoing investigations, then you are before me for nothing.
How do you reconcile that with the final?
No, but the final is always based on, we all read judgment. It's on because the judge is saying that you are before me and you've exhibited a discharge, whatever, that the charges have been discharged. If it's been discharged, then it's moot. But if there is an ongoing investigation, of course, the judge will not continue on that tangent because he's not.
So why strike out the application?
The judge said the reason the judge said the application is moot is that for there is no valid freezing order in the first place. Yeah. Following the withdrawal of the charges against Abdul Hanan.
So if he is rearrested, it's on a different if he is, please.
At the time that this ruling was delivered, he had been rearrested.
Yes.
But you haven't gone for any freezing order.
No, you don't need to because you don't necessarily have to.
I'm saying that
Yoko
administrative step has not been taken.
And that would not be before the judge because they may not have come to the judge.
But Yoko was there.
What you are saying is that as a matter of fact,
yes,
since the withdrawal,
yes,
there has been a new
that is what they don't want to hear.
No. I'm asking you.
Yes.
Are you confirming?
Yes.
That since the withdrawal of those charges, there have been a new.
Yes. I am telling you, by Yoko, by the lawyers, yes.
The withdrawal was done when, and if we know the date of the withdrawal, we will know whether it has been time for them to go for a confirmation.
That's a different matter. If they don't, if they haven't, you won't say there's not been a freezing order. You will go to court.
But if you don't go for a confirmation,
what you did also lapses. Then the lawyers will have to go to court and then seek to set aside that order because for lack of maybe refusing.
Can I also say my one small thing?
But you cannot say there's not been a freezing order.
Can I say my one small thing?
Please allow. You've said your own.
The withdrawal was made on the 5th of May 2026.
Okay.
So if there is a new freezing order from the 5th of May 2026, there would have been a confirmation.
Thank you.
And I'm saying that if they have
which will not be known only to Iyoko privately.
Thank you.
I'm saying that if they haven't done it, the solution would not be to say that there isn't a freezing order at all.
Yeah, finish your point.
I beg, people must know something.
We need to
There's something called expressio unis.
Allow me flow.
The expression of
you talk a lot and then you forget yourself that you have been talking.
No, because they are all over me.
Kofi, go on.
When I heard you say all the things you said that you didn't allow me.
The expression of one thing implies the exclusion of other. It is said here, it is moot, there is no valid freezing order. It cannot be that there is. 1. 2, if you are being investigated, it does not mean automatically your account have been closed. 2, if your accounts are going to be closed, that thing must go before the judge must agree, and then it is closed, and you must know. It is not ex parte, it is not a secret. Okay, so, and the last point, what is implied can never overrule what is expressly stated. Okay? We have what is expressly written here. Stated. No. There is no evidence that there has been a new order freezing the account.
Yes. So Kofi, you see what he's asking, what he's saying is that Administratively, they would have done some, but it is not known. But the point that raises is that Iyoko was also in court over this matter.
That's the point. That's why.
So did they tell the court that there was a freezing order? If they had told the court that there was another freezing order administratively, can the court make a pronouncement and say there is no one?
Iyoko told the court that.
So can I also make my point and finish? Because you are trying to help me now. So he is implying.
No.
I beg.
I'm not implying.
Show me the order that says there has been a new freezing of the account.
He's implying and assuming.
And I'm saying when we have a court order in front of us, even that says that the old is dead.
If that order in writing,
you are telling me that implying?
Why did
it can't be a
Attorney General exhibit it to his new application?
And my last point.
No.
Yes, the Attorney General did not exhibit it.
In what?
Yes, the new application for revoking the leave.
The leave. Yes.
He would have added that since the withdrawal of the charges, there has been, as you say, a new freezing order.
No, but who is disputing it for the AG to file something to that effect? Who is disputing?
Because the judge has said in the ruling that there is none.
No, but the judge operated on the basis of these 4 properties, which has nothing to do with whatever may have been said. It's in respect of the 4 properties. No, read this. So I want
to finish what you are saying. That if you were the Attorney General,
yes,
and this matter came up, and you were going to court for a revocation, and you know that there will be. It will turn on this interpretation.
How would
you will still not exhibit?
You will
not exhibit that.
Where is the order?
Yes, they may file later.
If they
so say that when you say a supplement, that's different. They file later.
But at the moment, there's no dispute.
Okay,
if they file
the liberties of a Ghanaian citizen is at
they filed this only 2 days ago.
You said what? So they should respond and say there is no freezing order. Then the AG, if there is, would file a supplement.
Okay.
But at the moment, there is no dispute. Where is the dispute that there is no freezing?
He's landed. I'm being asked to take a break.
That was the evidence before that.
No, it is in respect of these 4. And I still submit.
Even if I have said that the implied cannot overrule the express, we have the express. He hasn't shown us every evidence.
I said,
even if the evidence, please, even if the evidence existed, okay, Hanan is fully within his power as a bona fide person without notice to go to the bank and say, I want my money.
Oh, I get that point.
And let the bank produce that other one. So how do you arrest a man, okay, who has no information, even if what you are implying is true?
Get that one.
Yeah, I get that one because in the bank refusing him, that we have said, the bank would have informed you that there is actually a new freezing order. If you are saying that there is a requirement of a new freezing order and same has been issued, the bank would have said so.
You are missing the point. The bank is not party to what happens in court.
Yes, but when a party comes to tell you and say that the freezing order has been discharged, you will tell the party that there is a new one.
No, Samson, what the bank holds or held all this while, assuming there is even no new freezing order, will be the old one. You are in court doing your thing. If you come to the bank and you seek to vacate the old, even the older, you should show the court, the bank, what you have to vacate what they have already.
Which is a court order?
No, the court order, they saw a lot of things because it has nobody.
The court order is
thank you.
The bank can understand the